We'll start the presentation the evening, and can I thank everyone for joining this evening. Tonight you'll hear from Justin Penn and myself, and we'll be talking about issues related to the accessorial liability under the Fair Work Act and what I might refer to as the penalty privilege. My part of this evening's presentation will focus on the first aspect, that is the issue of accessorial liability under the Fair Work Act, with a particular focus on what needs to be established in order to make an accessory liable for underpayment claims. Justin will then talk about the penalty privilege and cover such matters as what it is, who can invoke it, what its invocation means in a proceeding, and how it might be lost. We'll have some time at the end of the presentation for any questions that people might have, and you can do that if you are watching online through the website, and we can access them, and we'll do our best to answer those questions. Lastly, we've also prepared a paper to accompany this evening, so don't feel like you have to take your notes, but you can do what we all did at university and wait for the notes to be handed around at the end of it all, and that should be online in the next couple of days. So perhaps we move on to my part of the talk. I should just add those matters up there on the screen are just questions that are posed rhetorically, but the issue that I will focus my part of the presentation on this evening is that issue of what does someone have to allege and prove in order to make a person liable as an accessory for contraventions of the Fair Work Act committed by an employer that result in the underpayments to employees. And I'm going to explore that issue tonight through a consideration of the High Court's decision in Productivity Partners and ACCC, which was handed down last year, because it feels appropriate to address an employment issue through the prism of unconscionability under the consumer law. But really it's the most recent and quite detailed exposition of accessorial liability by the High Court, and our view is that the High Court's analysis will provide an answer to an issue that I'll come to in a moment, that has resulted in some divergent authority within the Federal Court and the Federal Circuit and Family Court Division 2. That divergence can be pretty simply stated. As most of you will know, Section 45 of the Fair Work Act provides that a person must not contravene a term of a mud and award. Section 50 provides that a person must not contravene a term of an enterprise agreement, and Section 44 provides that an employer must not contravene a provision of the national employment standards. Now, the particular debate that has opened up revolves around the issue of whether, in establishing liability for an accessory, the applicant, whether that be the regulator or an individual who's commenced the proceedings, needs to establish where the underpayment arises as a consequence of a breach of the unaward or an enterprise agreement, whether the accessory has to have knowledge of the award or the enterprise agreement, and the cases setting that I've set out on this slide might represent the one side of the debate, or the strictest side of the debate, which I often refer to as the Potter line of authority, which holds that in order to establish the accessorial liability, one has to prove that the accessory knows that a particular award or the particular award applies to the employee's employment. Extrapolating that out to an enterprise agreement, the argument would be that they have to know that the enterprise agreement applies to the employment. There's a slight variant of that authority, and that was the one set out in Divine Marine Group by Justice White, where his honour ameliorated that slightly, where he held that what has to be established is that that knowledge of the specific award or applying to enterprise agreement, the specific enterprise agreement, doesn't need to be proved, but you have to establish that the accessory had knowledge that an award did apply. So that's what I said, that's the stricter line of authority. The alternative and perhaps slightly more generous line of authority is that which is sort of encapsulated in the reasoning of Justice Flick in the ABCC and Parker decision. And we've set out there on the slide the extract or the relevant extract from the decision. The short point being, His Honour's view is that it's not necessary for someone to allege and prove that an accessory knew that an award applied in order for them to be liable. His Honour's reasoning or rationale was that given that the primary contravenor did not need to have knowledge that an award applied, it would be unusual that you would have to require the accessory to have a greater level of knowledge. We've highlighted that part of the extract of the decision there. In particular, the focus on the last sentence, for the purpose of accessorial liability, all that need be proved is accessory had knowledge of the conduct. We're going to proffer a view this evening that Productivity Partners supports this line of authority rather than the more stricter line of authority, and we're going to proffer the view that that derives from the focus that the High Court, or particularly the relevant judges that considered this issue in the High Court, their focus on the conduct of the primary contravenor, in our view, supports this line of authority, and that's what we'll seek to establish this evening. Now, the alternative, what I might call the Flick line of authority, has got or have obtained support within other judges of the federal court, including Justice Katzman and Justice Rangier and Hu, and that in effect gives us the line of debate within the courts. What we do see, and perhaps this will be the experience of people online tonight, is that there are perhaps we could say inconsistent approaches being adopted by judges in the, what might say, the lower courts in the hierarchy. Most recently, in a decision of Fair Work Ombudsman and Char Time, Justice Manasarides applied the stricter Potter Divine Marine Group line of authority, in effect overruling other decisions that he had previously made, where he had adopted the, what I might say, the Flick line of authority, Justice Flick line of authority. His Honour in Char Time came to the view that, strictly speaking, the dicta, the decision in Potter and Divine Marine Group represented the dicta in those cases, and therefore that was the part that was binding upon him. Justice Humphreys in the Premium Travel Solutions went the other way, and Justice Colvin and Wilson Security went back towards the Potter line. So we really do have quite a stark difference between the Federal Court and the Federal Circuit and Family Court of Australia, Division 2 judges, about what needs to be established. and it really is a matter that ultimately will need to be settled, and it's ripe for being settled by an appellate court, and time will tell whether that happens. But the question then becomes, well, what will or what should a federal court, an appellate court, decide? And that brings us to the decision of the High Court in Productivity Partners. Now, there'll be a little bit more information in the paper about the case itself and about the background of it. As I indicated in the opening, it's a case that was considering two primary issues. The first was the issue of unconscionability under the Australian consumer law, and the second issue being whether or not a manager or officer of the company who was found to have been liable for contravening the ACL was also accessorially liable for those contraventions as well. Just very briefly in relation to the primary, the facts of the case, it involved a school or education institution that was offering courses to students, a number of them who were from overseas or non-English speaking background, and a part of the business model was to engage a third parties who would effectively drum up the support or the students and sign them up to the courses. There was a process in place whereby if students remained enrolled past a census date, the students would then be liable for the course fees, which would be paid to the the vocational education company, and the students would incur a debt to the Commonwealth for those amounts of money. The company, the school, had in place some control mechanisms by which they sought to, in effect, weed out those who may not necessarily have been intending to complete the studies, and therefore try and reduce or remove the amount of those who would incur these debts and debts to the Commonwealth for courses they may not intend to complete or may not necessarily need. The heart of the case was the decision by the education institution to remove those control parameters, and that which they did do, and it ultimately led to an increase in risk that people, as I indicated before, people who weren't necessarily intending to complete the course of study, or who perhaps weren't suited to the course of study, would ultimately incur these quite significant debts. I think the facts of the case demonstrated that after they removed these control mechanisms, which one of them included ringing up the students and the like, there was quite a significant increase in remuneration to the education institution, and the flip side being an increase in liability for a number of individuals. So that was the parameter of the case, and the federal court ultimately found that the removal of those control systems amounted to, among other things, the statutory unconscionability. The question then turned as to the liability, the accessorial liability of the Mr. Wills in the case. In the High Court, there were 6 separate judgments that were delivered, but essentially only four of those were addressing matters that we're interested in this evening. And the other point to note about the judgments that did address the issue of accessorial liability in any real detail is that all of the judgments considered the liability in that case, or the accessorial liability, by analysing or referring to the leading and oft-cited decisions in York and Lucas and Georgiani. The relevance of all of that is that, as we all know, when we come to analyse our cases of accessorial liability under the Fair Work Act, they are the leading cases that the judges turn to and analyse in deciding those questions, and they're the cases that are at the heart of what I might call the differences in opinions that I've shown through those cases. So just turning now firstly to the joint judgment of the Chief Justice and Justice Jago, I think I would describe the way that their honours approach this, the question in the case, as a rather sort of orthodox consideration of York and Lucas and Georgiani. And they also focused a little bit of attention on rural press in the High Court, bearing in mind that that was a case, the Productivity Partners case was an issue about unconscionability under the consumer law, and therefore the relevance of rural press to that consideration. The Chief Justice and Justice Jago, and this is perhaps one of the more relevant extracts from their decision, held that when you're assessing the issue of an accessory's liability, bearing in mind that when we are talking about accessorial liability, we are talking about two separate concepts. There will only ever be one contravention of the act that you are considering, and that is the primary contravention, and then one's analysing whether the accessory is involved, and I'll use that term generically because of the differences in the way that the legislation identifies that, whether it's an aiding or abetting or the knowingly concerned, among other matters, with the contravention of the primary party. And it's important to understand, in our view, and keep that distinction in mind, because it allows you to understand these extracts from Productivity Partners and the way you would analyse and assess the accessorial, the accessory's liability and the knowledge that they need to have in order to be found to be liable. So what the Chief Justice and Justice Jago said is that the relevant distinction is not between facts and law, nor is it between the objective facts and evaluatory facts. It's between, and we've identified this, essential matters constituting the contravention and the character, quality, nature, etc. And you see from the last sentence, they say for accessorial liability, knowledge of the former is what's required, but not knowledge of the latter. Now, I'll come and explain this a little bit towards the end of my part of the presentation. But I want to introduce the concept that when the current approach to considering accessorial liability, one often sees judges identifying what they say are the essential facts, and that's how one sees a bit of the distinction opening up, where one will say the primary contravention can only be established where you identify the award, and then they argue from there, because you have to identify the award, that's an essential fact of the contravention, and therefore the accessory needs to know or have knowledge of the award or the enterprise agreement. What's important to note here is the reference to essential matters, not necessarily limiting to the facts per se. The next joint judgment, I should say that it wasn't a joint judgment, but it was a judgment of Justice Gordon, with whom Justice Stewart agreed on this particular issue. Their focus was really much more, if I could say, narrower in terms of the particular issue that Mr. Willis, the alleged accessory, and the accessory was challenging a decision on the appeal, had raised in answer to his liability. And that particular issue was that he argued that what had to be established for him to be liable was that he knew the college's conduct was unconscionable, or that he knew it was contrary to the ordinary standards of commercial people. So they really focused their consideration much more, I could say this narrowly, so we started with the orthodox sort of approach of York and Lucas to a more confined, narrow approach of Justice Gordon, where they focused on what the argument of Mr. Wills was in the High Court, and that's how one might approach a consideration of their judgment. Now, if you're going to read and spend any time on Productivity Partners and the judges' decisions, I'd suggest you read and focus on what Justice Edelman said and Justice Beach-Jones. Perhaps not unusually for someone like Justice Edelman, given his background, I think his approach and his consideration and analysis is much more scholarly, and he takes the time to explain cases like York and Lucas and Giorgiani and explain why in those particular cases the accessory was found liable for the relevant the contraventions committed by the primary. So he analysed it in terms of the breaks and the things like that. So as I said, so if you're going to spend a bit of time, and I must confess it took me a number of read-throughs of those judgments to properly understand the analysis that was being undertaken, but I would sort of commend those judgments to you. Now, what His Honour said is that what has to be established in terms of the knowledge of the accessory is an intention to participate in the conduct. Again, you will note I focused before on Justice Flick's extract about and highlighting what he said about the conduct in Parker. And it's the intention to participate in the conduct that amounts to the essence of the primary offence or contravention is a central requirement that must be satisfied before liability for one person's offence can be attributed to another. So this is this attribution, this concept that I introduced a short while ago, keeping in mind that when we're talking about accessories, we have the primary contravention and we're talking about or considering someone else's liability. Here Justice Edelman refers to as being attributed to them. And he says in order to undertake that there are 3 steps. The first is the identification of the essence of the primary offence or contravention. And then the second is the identification of the acts of the accessory that amounts to involvement in the essence of the primary offence or contravention. And then thirdly, identification of the intention of the accessory to be involved in the essence of the primary offence or contravention. Now, His Honour said that quite often the first step there is going to be the hardest, and clearly that's the most difficult one, or the one that throws up the most difficult questions, and obviously that's what we see in the division in authorities that I referred to earlier this evening. But I think this observation is quite important in terms of the first element. He says it doesn't require knowledge of every fact required for proof of the primary offence or contravention. Only those facts necessary to intend to participate in the essence of the offence or the contravention. And again, he's using this terminology of essence of the offence or contravention, and again, looking at it through the prism of what did the primary contravener do. The last judgment that dealt with it in any real detail again was looking at it in a similar way that Justice Edelman did, and that is a little bit more scholarly. Justice Beach-Jones being one of the judges with particular criminal background on the High Court now, and Justice Gleeson agreed with him on this issue of his analysis. And here he says at 339 that was there knowledge of the essential facts. And he said that accessory's knowledge must concern the relevant nature, character and circumstances of, again, just focus on these words, the principal's unlawful act, but does not necessarily extend to knowledge of an element of the contravention that is a consequence of that act. Whether the accessory had knowledge of the essential circumstances, matters or fact requires a close analysis of what the principal's contravention consisted of. So again, we have the judges focusing not specifically on what might be said to be a rote reference to identify each and every fact that has to be established in order to make out the primary contravention, but it's a focus on what did the primary contravener do in order to contravene the section. Now, all of these extracts are given in an abstract. They'll make a lot more sense when one reads the decision in the High Court, and one then sees the focus of the High Court identifying, well, what did the primary contravener do? And they focus on removing the particular control mechanisms. What information did the Mr. Wills have at the particular time? And so the focus wasn't necessarily on the question of, for example, the Section 21 of the ACL provided that that a company must not engage in conscionable conduct in trade or commerce. There was an analysis of whether or not you had to prove Mr. Wills knew it was in trade or commerce or anything like that, which obviously has to be established in order for the primary contravention to be made out. But the focus was his knowledge, firstly, on knowledge of the conduct of the primary contravener, and then secondly, which is always another aspect that's we're not focusing on tonight, that the other aspect is what did they do to associate themselves with the conduct. And so in our underpayment cases, ordinarily the alleged accessory might be the person who has signed off on the letter for the particular pay rate or the contract or the pay slip or something like that, or they have knowledge of the rates that are being paid. That's the associate himself with the conduct. So just where do we go? I think there are a number of propositions that fall out of Productivity Partners, and I think we can distill it down to perhaps three important points to remember. The first is that identifying what are the essential matters or the essence or the essential circumstances of the primary contravention is going to be crucial. The second is, whilst that might be difficult, picking up what Justice Edelman said, it requires the focus to be given to an analysis of what the principal or primary contravener's conduct consisted of. And then the third point is that establishing accessorial liability doesn't require knowledge of every fact that is required for proof of the primary offence or contravention. So we think applying that reasoning, and when it does get applied, it will get applied at some stage by an appellate court, applying that reasoning will ultimately support the Parker line of authority in terms of focusing on the conduct of the employer. And really what needs to be established is whether or not the accessory knew, in effect, the rates that were being paid by the employer. Did they have knowledge of those rates? They don't need to know whether or not the rates therefore were lower or different to the award in order for them to be liable, because picking up if we focus on the conduct of the employer, the conduct of the employer is the actual payment of the rates, because when you look at judge it through the award, the fact is the payment of the rates, whether it is below the award, is a fact that will be established, but the employer doesn't need knowledge of that. All that needs to be established is the fact that they were paid and the knowledge of the amounts that were paid. And secondly, obviously there'll have to be the conduct that associates with the contravention itself, as I indicated before, perhaps signing off on the employment contract that has the rates of pay in it, or the pay slip that acknowledges those rates of pay. But until it's clarified by an appellate court, it seems that particularly if you are in the Federal Circuit or Family Court, one still will have to prosecute the cases on the basis that you'll have to establish the accessory has knowledge that at least an award applies, perhaps the specific award, but relying upon Divine Marine Group, you could argue that it's simply an award applies and prove the knowledge through that prism. And
Why would you do that? Why would you run it that way?
because that'll be that's the current line of authority.
The concrete line of authority.
There is. The question is if you're prepared to run the case and run it to an appeal level or the like. That'll be the gamble one has to take. You can run the contrary line and then lose it, if you like, but
I guess you could run them on the alternative on either basis.
you could certainly run them on either basis. I think the point really is that if you're commencing as an applicant and you're seeking to establish the liability of the accessory, you ought to apply the more stricter approach, lest you end up running your case and the judges say, well, that's all well and good, but you have to establish this and you haven't established all of that. Unless, of course, you're prepared to run the case on the basis you run it at first instance and you really don't mind what the answer is because you run it on the flick line of authority and prepared to say, well, they're wrong about that and take that on appeal.
I guess the Fair Work Ombudsperson can do it.
Yeah, well, that's correct. The regulator can do that, and there will be a time when, no doubt, that happens. So that's brought me to the end of my part of the presentation this evening. I'm going to hand over to Justin Penn, who will deal with what I'll call the penalty privilege. And then at the end of Justin's presentation, we'll have some time for some questions if anybody has those.
Thanks, Jamie, and thanks for delivering that first half of the presentation. I might actually skip to my last slide because I think it offers the neatest segue into what I'm about to talk about. That last slide being a different rule or law. That's Newton's third law of motion. For every action in nature, there is an equal and opposite reaction. Given what Jamie had said about the expansion or arguable expansion of accessorial liability, or at least the expansion, how it might be considered in wage underpayment claims, this part of the presentation deals with what might be that equal and opposite reaction. How might those who advise employers and those who advise alleged accessories to contraventions of the Fair Work Act, how they might respond, taking into account what the High Court says in Productivity Partners and what regulators and applicants might do in respective claims for accessorial liability. So that's the context that's the context in which this part of the presentation should be sort of examined. Returning now to the penalty privilege, which is a lot less wordy than the privilege against penalty. Sorry, the penalty against self-exposure to civil penalty. The starting point is, what is it? The privilege against self-exposure to civil penalty is a procedural rule. There's an argument about it having some substantive effect, but the authorities refer it to as a procedural rule that applies in judicial proceedings, and the purpose of which is to ensure that a party who alleges criminality or other illegal conduct is to prove it. We'll see what that effect has on the court's procedures. But the other comment to make, of course, is that it's uncertain but unlikely that the privilege applies outside of curial proceedings. That's why I think the courts have referred to it as a procedural rule. I'll talk later about what it actually does, but that's what the privilege is. As a starting point, though, the invocation of the privilege is and should be a powerful tactical consideration, because in a contest between the privilege and a rule or order of the court, the rule of or order of the court yields to the privilege. That is, if orders are made requiring, for example, and we'll see this in action, requiring a natural person who has invoked the privilege to produce certain documents, to put on an affidavit, to put on a defence, that order will have no effect as against the privilege. Who can invoke the privilege? As I just mentioned, those that can invoke it, those who can invoke it are natural persons. A corporation enjoys no such protection. The privilege is also personal in the sense that it can't be claimed by someone so as to not incriminate another person. There's a reference on the slide, and as Jamie mentioned, further detail to be put in a paper that will be published soon. To this case, Meneses and Directed Electronics. And the question mark in the slide is, what about a one-person company? How does the privilege work where you've got a corporation that's essentially a stand-in for a natural person? Meneses tells us that there's little work for the privilege to be to do in those circumstances, but certainly not nothing. Some comments from that judgment there are that a corporate defendant may be required to provide documents and information which may tend to incriminate its officers. So the corporate defendant can't exercise its privilege to shield, can't exercise a privilege rather, to shield its officers, its natural person officers, even though they might be said to be accessories. A corporate defendant further cannot invoke privilege on the grounds that an order or requirement to produce documents or information might tend to incriminate a natural person, such as a director. Again, the director might turn out to be an accessory, might be pursued as an accessory. An order against a company to produce documents might incriminate that director as an accessory. But the privilege has offers no real aid there. There's a few other points in what's said in Meneses, but as I said, that'll be expanded upon in the paper. Something, though, that was said in Meneses that has relevance and comes to life from that question, what about a one-person company, is this, and this is paragraph 153 of that judgment. Again, as Jamie said, you don't need to scribble down paragraph references now. The notes will be circulated afterwards. But what was said there was, in circumstances where a company is essentially a one-person company, and that person, the natural person director, is entitled to rely on the privileges to resist production of documents, it is necessary to consider mechanisms by which the company could produce the documents other than the natural person doing so on its behalf. So there is this interplay between a natural person who's essentially being required to be relieved of their privilege to comply with an order against the company. In that case, for example, orders were able to be made requiring that natural person to produce those documents on behalf of that company, but that was really through the interposition of, by way of the appointment of a receiver for the company. That was done under the Section 57 of the Federal Court Act, and that allowed, effectively, the natural person director to maintain his privilege, to not have a court order offend his privilege, but for the order requiring the production of documents to be complied with. It wasn't the director who had and maintained the privilege that provided the documents. It was the receiver appointed to the company. Now, having spoken about who can invoke the privilege, what it is, I think people are probably wondering, well, what can it do? Why would this privilege be something worth thinking about or considering? And why do I say that its consideration ought to be the equal and opposite reaction to what was said by the High Court and Productivity Partners? Well, the privilege against self-exposure to civil penalty can be relied upon to resist at least these 4 points on the slide: a requirement that a defence be filed that complies with the rules of pleading. That is, one can file a defence and rather than admit, deny, or say that you do not know and therefore cannot admit or deny an allegation contained in a statement of claim, one can simply invoke the privilege in response to particular paragraphs. And that can be, again, forensically very powerful because it doesn't give the game away. It in furtherance of the purpose of the privilege, requires the person who alleges criminality or other illegal conduct to prove it. You don't need to admit, but more importantly, perhaps, you don't need to admit, nor do you need to deny. It's left to the pleader, it's left to the applicant to prove and to work out exactly what can and can't be proved on their own case. It can also be used to resist an order for the filing of witness statements. That extends to affidavit evidence or other forms of evidence, written evidence before the court. It can be used to resist an order to answer interrogatories. And it can be used as a bulwark against the production of documents by way of discovery or a notice to produce or a subpoena. The benefits of the privilege in this way are really twofold. First, it can be invoked to effectively force an applicant to put forward their case, both pleaded and evidentiary, to the individual respondent, that is, the alleged accessory, in a case involving a natural person accessory, thereby allowing that individual to formulate their defence, again, their defence both on a pleaded and evidentiary basis, with the benefit of the whole of the applicant's case already put to them. That's to say that the applicant has to put on their whole case, pleaded and evidentiary, before the individual respondent need answer it. And that can allow for some tactical thinking. The second broad benefit then is that the privilege can be invoked to effectively immunise the individual respondent from compulsive court processes to answer questions or produce documents. Such use of the privilege might have particularly significant consequences in cases where discovered documents or documents that otherwise sought to be produced reside or are in the control of a personal phone or a personal device that belongs to the claimant of the privilege and not the company. And that's because, as we had touched on in Meneses, if the company has a document, the company must still produce the document. But if the claimant of the privilege has the document and only they have the document, it cannot be obtained through them. And because the company doesn't have control of it, it can't be obtained through the company. Returning now briefly to what Jamie had discussed about what needs to be known, what the accessory must have actual knowledge of in respect of an underpayment claim. Whilst the bar, on one view, might be lowered, whilst that liberal approach, the generous approach, the Parker Flick approach, might be the new orthodoxy, and I agree, and as we said, that is our view, that's certainly our view. The privilege might still have work to do to make more difficult the applicant, the pleader's job, where they don't necessarily have all of the evidence to make good, necessarily, all of the essential matters that constitute the contravention. And having a regard to the complexity and structure of contemporary corporate employers, the lack of compulsive productive powers might in fact make that a difficult undertaking. The last part of this part of the presentation, it really addresses how the privilege might be neutralised or otherwise defeased. How, where the privilege is pleaded, it might be gotten around or beaten. So an applicant is entitled to invoke the privilege where there is a real and appreciable risk that proceedings will be instituted for a civil penalty or would otherwise tend to subject the claimant to a penalty. That means that it's not necessarily the case that the claimant of the privilege is staring down the prospect of a civil penalty being imposed upon them. There simply must be a real and appreciable risk. That said, one way to thwart the claim would be to simply exclude that from the pleading, or perhaps expressly state that no such penalty is sought. There's case law to the effect that a regulator not seeking a penalty in proceedings against a regulated subject meant that the individual, the natural person, the subject of those regulatory proceedings, could not invoke the privilege because there was no real and appreciable risk, because the regulator had not sought the penalty. That case, and again, all these authorities will be contained in footnotes in a paper that will be circulated or that will be published. That case, in fact, involved a regulator amending its pleading to remove the a mention, a reference to a civil penalty, perhaps to rob the individuals of the privilege. The privilege as well, where it is available and has been successfully invoked, can be advertently, or unfortunately inadvertently, waived by a party who would otherwise be entitled to claim it. So, for example, on the slides, we have 4 examples of when that privilege has been waived. The filing of a defence that contained positive defences, notwithstanding that the privilege was expressly invoked. There's an inconsistency there, and as we might all know, waiver is functionally about inconsistency. You say one thing, but you act in a way that's different. You say that you don't want to. You want to put the applicant or the plaintiff to proof, but you put in a positive defence. That's an inconsistency. That's the waiver. The second example is filing an affidavit purporting to answer charges put against the party. The third, and these are all taken from the case law, these are all examples from particular cases, so it's a non-exhaustive list. The third, consenting to the making of orders for discovery. And the fourth being the provision of a prior voluntary statement, including in separate concluded proceedings. That case dealt with the making of a statement in unrelated, I think, proceedings that had nothing to do with the present proceedings, in which the privilege was later sought to be invoked. For clarity, for abundant clarity, the waiver extends only to the inconsistency with a claim for privilege. That means that waiving the privilege in one respect or in some limited way does not mean that you are denuded of it for the balance of the proceedings. One can waive the privilege partially as to one thing, advertently or inadvertently, but comfortably claim it later. So, in a case that mentioned by Jamie, actually, but a different aspect of the case, a different part of the proceeding, Fair Work Ombudsman and Who provides a neat example of waiver and of privilege, the privilege being waived, but only to a limited extent. In Fair Work Ombudsman and Who, a respondent, an individual respondent, who had made admissions and positive allegations in their file defence, was found to have waived privilege in respect of those admissions and positive allegations, but this did not disentitle them from relying on the privilege to later resist a compulsive order to file an affidavit in respect of the matters for which the privilege had not been waived. So that's an illustration of waiver being limited in both the subject matter, that is, waiver was only affected over those matters where the individual respondent had made admissions or had put positive allegations. That's the subject matter waiver. But it was also only waived in respect of the particular compulsive process. That's the filing of the defence, the putting on of a defence. The privilege wasn't waived in that later stage of putting on evidence, and it wasn't waived in respect of matters that were not admitted or matters for which positive allegations had not been made. Of course, the most common way in which the privilege is waived is simply that it's not considered and not invoked by the party capable of doing so. That's the most straightforward way in which the privilege either doesn't arise in a case or isn't relied upon in a case. My own short concluding remarks on my part of the presentation in conjunction with Jamie's are that it's uncontroversial, I think, to say that Productivity Partners was a significant win for an Australian regulator. 7 judges of the High Court found in favour of the Australian Competition and Consumer Commission, albeit for the different reasons and with different emphasis, as Jamie had mentioned. But it was a significant and quite decisive step in the direction, I think, of acknowledging the application of accessorial liability to situations where less matters need be known than perhaps earlier thought. It remains to be seen how Productivity Partners will affect the law of accessorial liability as it relates to wage underpayments or other areas of the law. But Justice Edelman said there in Productivity Partners, quote unquote, "These are civil cases, but the principles concerned have far-reaching consequences through both civil and criminal law." As I mentioned, I think that's right. And as I said, I think if the new orthodoxy is that it has become, quote unquote, easier for accessorial liability to be visited upon an individual respondent, practitioners, regardless of their stripe, plaintiff or respondent, whoever you act for, would be commended to revisit and reflect on this privilege, this penalty privilege. You shouldn't waive the opportunity to do so.
Thank you, Justin. I think one thing to add about the penalty privilege that clients and solicitors often ask me about is, well, what do you do with it? What happens after you've invoked the privilege and you've decided not to produce documents or put on a responsive defence? There comes a stage in all proceedings where the person who's invoked the privilege needs to make a decision whether they maintain the particular privilege. And that time can happen. You can waive it at any time, you can change your mind at any time, but generally if you maintain it, once the applicant closes their case, and so this is probably a little thing that you should listen out for when you're sitting in the court. The applicant starts their case, they do their submissions, they call their evidence, and then you'll hear this little interlude. Is that your case? Or the applicant will say, that's the applicant's case, or the case is closed. Then the decision has to be made. And the way that these, particularly the Fair Work Act proceedings, proceed is that at that stage, if the person who's invoked the privilege wants to go into evidence, they would then generally say to the court they wish to file an amended defence, and they might put on positive defences or something of the like, or they might make other admissions, then they'll serve some evidence, generally an outline of their outline of their evidence, or an affidavit, and subject to any order of the court allowing some time to consider that material, and generally it's not that long. The case will then proceed, and the applicant will then have to start to cross-examine on the evidence. So ordinarily you'll see procedural orders made for the hearing that will involve, and if you're acting for someone who's invoked the privilege, you should make these orders that once the applicant has closed their case, that if the individual wishes to waive the privilege and go into evidence, then you include an order that at the close of the case of the applicant, that any amended defence is filed, and serve any affidavit or outlines of witness statements as you're proceeding. So that's the procedural way that these unfold. Well, I don't know that we've got any other questions this evening. Thank you for tuning in. We appreciate all that. As we've said a couple of times, in the next few days there will be a paper appear on our website. That'll be the place where it's available. Visit the website, and it should be there for you to download. So thank you again.